but to talk about the legislation that came out a week ago today, the Family First Coronavirus Response Act. If you've seen the document, the actual document, it's pretty intense. So we are going to give you the Cliff Notes. Nathan's going to give you the Cliff Notes. Hopefully it'll be a little more digestible. And again, always feel free to reach out to me, to Nathan, to anyone at Fahrenheit if you have follow-up questions. Make this interactive. The chat function you can use. Feel free to jump in if you have something that immediately pops out. So we want to answer questions that are particular to you and your business and help you all immediately. So feel free to jump in, and then we'll do some Q&A at the end. So without further, Nathan, go ahead and take it away.
Thank you, Jay. First of all, it's great to be with you this afternoon. I appreciate the opportunity to get in front of you and to offer some guidance on this new and developing legislation that we've all been monitoring over the last couple of weeks. What I want to do is I want to go through the act a little bit with you. I know many of you have been keeping up with the act and making sure that you understand the basics. So I'm sure everyone on this call has some degree of basic understanding of the act. I do want to spend a little time going through it with you, really the high points, kind of just to make sure that we have somewhat of the same basis of understanding, that everybody's kind of on the same page. And then hopefully we can get into some questions that are specific to your situation and questions that we may be able to kind of drill down on the act a little bit more. So that's what my plan is for this afternoon's call. First of all, the law is pretty expansive. It's pretty big. Obviously, nothing that comes out of Washington is small, and this act is no exception to that. But there are some aspects of the act that I don't plan to spend a lot of time with. They're very important. They play critical parts of making sure that our government properly addresses the current situation we're in. But for our purposes today, I think we'll kind of skim over them just a little bit. You know, the law was signed into effect on March 18th. It was due to go into effect 15 days after signing, which would be April 2nd. I did see some information this morning that indicated that effective date is now April 1st. So going forward from there, all of the provisions of the act will take effect. The act includes funding and some guidance on things like child nutrition, the supplemental funding of SNAP and a few other government programs is included in the act. Again, those are important things. We're not going to spend a lot of time on them this afternoon, but they are important. Information on free testing for the coronavirus, how health insurance plans are going to be working to make sure that individuals, employees, and members of their health coverage have access to testing is all covered in there. And there is a substantial section of the act that provides for things like assistance with state unemployment insurance administration funds, making sure that there's enough funding there to cover what they anticipate will be kind of a surge in unemployment claims over the next several months. It encourages states to make sure that they are looking at their laws, their rules around the application of unemployment insurance. You know, things like how strictly are you going to enforce the provision that people who receive unemployment are actively looking for jobs, those types of things, because they realize things are going to be slow and they don't want to see people lose their coverage because of some of these aspects of state law. So there is a fairly large section in the act that provides for support and funding of state unemployment insurance plans. The main things I think that we'll spend a lot of our time on today obviously pertains to the time off benefits, the benefits that have been provided under the plan for employers with fewer than 500 employees. I know one of the questions I've gotten recently is, why did they set it at 500? Why are smaller employers kind of bearing the brunt of this as opposed to larger employers? I don't have a great answer to that. I don't know why they set it the way they set it, other than to say, I think the assumption from the government was that larger employers are generally have a much more expansive menu of benefits for employees, for sick leave, vacation time, personal time, and they set the bar at 500. I guess we can argue whether that's a good point or a bad point to set it at, but that's where it is set. So it is set at that 500 mark. And the first thing that we'll cover is the paid sick leave. Now, paid sick leave is new. I think that one of the things that jumped out at me, and the key thing is for employers to remember, is that the 10 days of paid sick leave that is provided under the Act is in addition to what the employer may already provide. I've gotten a few calls and people say, well, we provide 8 days of sick leave, so we only have to add 2 more. And that is unfortunately not the case. These are 10 additional days of sick leave that must be provided. They're separate and apart from what may already be offered. Now, the sick leave is broken down into 2 components as far as how it's paid. The first is if the employee is taking the leave because they are themselves subject to a quarantine order, or they have been advised by a healthcare provider to self-quarantine, or the employee themselves is experiencing symptoms and they are seeking a medical diagnosis. In other words, if the sick leave is being taken for the purpose of the employee's personal condition or circumstances, then the benefit is paid at 100% of the employee's regular paycheck. The Act does set some maximums. If the maximum is $511 per day or $5,110 over the course of the 10 days as a total. So if the employee makes less than that per day, they're covered. If they make more than $511 per day, that is the ceiling. That is where it caps out. The plan also goes into reasons for leaves that may extend to family members or others. And that means if the employee is taking time off to care for individuals that are subject to quarantine, if they're caring for a child whose school or daycare center has been closed, if they're experiencing other quote unquote substantially similar conditions, and these are going to be defined by the Secretary of Health and Human Services, the Secretary of Treasury, and the Secretary of Labor. If their reason for taking leave falls into one of those secondary classifications, then the pay for that time is at 2/3 of their regular paycheck, their regular hourly or daily paycheck. And again, the maximums here are set at $200 per day or $2,000 over the course of the 10 days. So the sick leave is there and it's available. It's not retroactive. It's any time that is taken from April 1st on. The law does extend the availability of this sick leave until the end of this year. So it's extended until December 31st of 2020. And so anytime taken between April 1st and December 31st is what is subject to this particular law. Now, there are some limits that are placed on administration of the sick leave on employers. There are certain things you can do and cannot do. For example, you cannot require an employee use their existing or their accrued time off benefits and vacation or sick leave or personal time. You cannot require that they use that time for the payment of this sick leave. It's, the sick leave cannot be carried forward. That's a different situation. But it is something that you can also require your employees to provide you with updates. The law also allows you to require or request that your employees provide you with as much notice that they're going to take leave as is possible. And you can request that they provide you with kind of regular updates as to their condition, their status and whether or not they will use all 10 days at one time or whether they'll be back to work under certain circumstances. You cannot discipline an employee, either termination or any form of discipline, when they use this leave. So there are some things on there that you cannot do. And in other words, I don't think there's anything you can do to discourage the use of this sick leave if the employee is applying it to one of these situations. One of the other requirements, and it applies to all this time off, is that you must post a notice to your employees in your workplace that basically advises them of their rights under this law. The Department of Labor is scheduled to release a form notice that you can post in your workplaces. That is due out either today or tomorrow. I have not seen anything as of this morning that they have released that document, but I would encourage you to kind of keep an eye open for that. It should be coming soon. And as soon as you get that, I would suggest that you simply print it off, and the copy is sufficient to post around your workplace and all places that you can think of, and get that posted as quickly as possible. The other thing I want to kind of stop and make a little quick note of is that the Department of Labor has said that they're going to waive enforcement for 30 days after this law has taken effect. What that means is basically, if for some reason someone requests leave and the employer is not 100% up to speed on what they need to do under the law, and they make a technical error in providing the leave or allowing the leave or paying the leave, they're not going to go to the EEOC and sue you right away. They're going to give you a period of time to kind of adapt to this and make sure that any errors that you made are corrected, especially if they feel like those errors were made in good faith. So it's something that we need to keep in mind. I think everybody is going to do this as well as they possibly can, as quickly as they can. But because of how things are moving, it is important to make sure that you kind of keep that in mind. The Department of Labor certainly understands there are going to be some errors made in how this is administered on the employer level.
Hey, Nathan, can I jump in for a second?
Sure can.
What are some of the clauses in the legislation around, let's call it proof of necessity for these? You know, maybe am I going to determine myself that I need to be quarantined, or am I going to, I mean, is it the old school, I need a doctor's note, or what is to protect the employers in this case? You know, what are some of those provisions?
There's not a lot of provisions, Jay. They're, you know, even in cases where employers have part of their policy where they require employees provide them with a doctor's note, they are encouraging employers to be either scale that back a little bit or be mindful of the fact that because the healthcare providers are going to be swamped with this, they're indicating that it may be difficult for your employees to get those notices. So be patient with them, maybe scale back some of those requirements. But I think the bottom line is, Jay, there's not going to be a lot of certification that's going to be allowed to say that the employee must give you some form of proof that they need the time off. If they feel like they've run across someone who may have had exposure to the virus, and they feel themselves or their families are at risk and they want to self-quarantine, I don't think there's going to be a lot of latitude for the employer to challenge that. And they're going to kind of have to accept their employees' words on some of that type of thing. So, you know, I would be careful not to go too far with requiring too much proof, so to speak, from the employee.
Yeah, that's scary as it relates to the CEO audience. All employees, I'm sure, are hard charging, and we know no one would ever take advantage of a situation, but that's scary.
It is.
And while we're talking about it, if employees are furloughed, can they apply for unemployment?
Yes. Yeah, unemployment in Virginia, now unemployment in other states, the states control how unemployment laws are passed. Some states are much more difficult to get unemployment. Some states are not as difficult and under what circumstances. But I think it's safe to say that in most of the states, including Virginia, if an employee has been laid off or had their hours severely cut, which would be the case in the case of a furlough, they are eligible for unemployment compensation. So I think that is something that I've heard a lot of. I know employers are struggling with that decision. I think they still value their employees and want to make sure that they take care of them during this period of time. But because of business necessity, furloughs and layoffs are things that companies and employers are considering. And again, in the case of a furlough, I think they would definitely qualify for unemployment benefits.
Gotcha. Thank you. Sorry for jumping in there.
Not at all. Happy to do it. The second part of the time off benefits we're going to slide into is the expansion of the Family and Medical Leave Act, or the FMLA. You know, a lot of companies who are of the size 50 or more are familiar with the Family Medical Leave Act. Any of you who may have organizations that have less than 50 employees, this is kind of new territory for you. And what's important to understand is a lot of this infrastructure of the Family Medical Leave Act remains in place. And what they're simply doing is making some adjustments, some expansions temporarily to cover people for longer periods of time than may be provided by the sick leave, the Paid Sick Leave Act we just talked about. It's important to note a couple of things. First of all, for those of you who have, responsibility for FMLA right now, in the past, to be eligible for FMLA, you needed to be with the company for at least a year and have worked at least 1,250 hours over the past 12 months, be it a rolling 12 months or a calendar year. This act reduces that substantially to only 30 days. If they're with you 30 days, and the number of hours is irrelevant, then they become eligible for this new version of FMLA. And it's something that employers are kind of struggling with a little bit. The FMLA part of it is broken also down into a couple of parts. It's important to understand, and I've seen some confusion around this lately. The first FMLA is 12 weeks of job protected leave. The job protection aspect is still in place and it's still very critical. The difference here is also that normally FMLA is unpaid. In this particular case, and under this particular act, FMLA does become payable by the employer. And it's broken down in the following way. Number one, the first 2 weeks of FMLA are unpaid. Now, I've seen some confusion around that. Some people think it is paid. Everything I've seen and all the research I've done indicates that it is unpaid time. Now, this is an area where if you would like, and I would strongly encourage you do, if you would like your employees to utilize accrued vacation, sick leave, or personal time, this is when you can ask them to apply this to their time off, okay? These first 2 weeks during FMLA. While you cannot do it with the sick leave, you can do it during the FMLA period, especially during this 2 weeks of unpaid leave, okay? After those 2 weeks, there are an additional 10 weeks of leave that is available to the employee, and that leave is paid at 2/3 of their regular pay. And again, it allows them to do many of the same things, care for children, care for themselves, care for individuals which do not have to be family members. That's also important. FMLA is pretty strict, and it's called family medical leave because it involves the family. Under this provision, if they're staying home to take care of a friend who is not a relative, but they're under some kind of self-quarantine, they can take time off to do that under the FMLA provisions of this particular act. So it's important to keep that in mind as well. So it's 2/3 and it continues for 10 weeks. Although the act does not go into a lot of detail about this, I think it's safe to understand or to assume that some of the same provisions apply. For example, the 10 weeks does not have to be taken as a block. It can be done intermittently as the FMLA allows. In other words, if they need a couple of weeks, they take a couple of weeks, it's unpaid. If they need 2 or 3 more weeks and then they're pretty much ready to come back to work, they don't need to take the whole 10 weeks, but they still reserve the remainder of that 10-week total for the rest of this year. So I think the act really doesn't go into a lot of detail about that, but since it's borrowing so greatly from the FMLA, I think it is very safe to assume that's the way it's going to be handled going forward. So keep that in mind as well. So
Hey,
that's,
Nathan,
yes, sir, go ahead.
can I ask you just to repeat, you made the point about, again, as it relates to the audience and the CEOs and how to maybe help them. Repeat the point you made about being able to apply sick time or PTO.
Right.
You can't do it for the sick leave portion, but you can. Can you just re-hit on that point in case?
Sure. Okay. That is it's a very clean distinction between the two. Remember, the sick leave is 10 days of paid leave. Okay. They've made it very clear that of that 10 days, nothing can be used. An employer cannot require their employee to use their accrued benefits for payment of any of that time, any of those 10 days. But again, keep in mind, some of those 10 days may be 100% pay, some of it may be 2/3, depending on the reason the employee is taking the leave. Under the FMLA expansion portion, which is separate, you got that 2-week initial period. There's 10 weeks, there's 12 weeks total. The first 2 weeks are weeks that are unpaid. If the employee has no sick leave, they have no vacation, they have no personal time left for them to take, then that 2 weeks is unpaid until they kick into the 3rd week, and then they have 10 weeks of 2/3 payment. So because of the uncertainty around this, I know a lot of employers are saying that when I can require that they use their time, I'm going to ask them to use their time. And keep in mind that the only time you can do that is for those 2 weeks that lead into the FMLA period. And again, once that 2 weeks period is gone or their pay is up, then you switch to the normal formula. So it's something that employers, I think, are trying to get off their books as quickly as possible, depending on what their policies state. They want to make sure that the accrual for those benefits are used. And I think most employers are, again, wanting to make sure that their employees understand that is available to them. And it's important to kind of separate the two. The sick leave is completely off the table with regard to using that. The FMLA is where that would be applied if it's applicable to the employee. Okay. With any follow-up questions to that, or was that sufficient?
Yeah, I just thought that was a key point that could, again, help CEOs as it relates to their employees.
Yeah. The last point I want to touch upon, and again, I'm not an accountant, just like I'm not an attorney, and so what I'm saying is not necessarily legal advice. It's just my understanding of the act. But employers are also very interested in, if the government's asking me to pay these benefits, am I paying it directly, or is there some help from the government? And it's kind of to me a dual-edged sword. You're actually paying the benefits up front, but the government is allowing you to take a credit off of the payment of your regular payroll taxes to help pay for this. And there's some key points to this as well. Number one is each month, or I assume it's each month for most of you, you're paying payroll taxes that have been deducted from the employee's paycheck for Social Security and Medicare, and the employer is making their contribution to those two benefits as well. And you take that and you remit that to the federal government on a certain schedule. What the act is saying is that if for a month I normally would pay or remit to the federal government $8,000 in taxes to the government, which represents the payment contributions of all my employees, not just those on leave, all my employees and all the company's contributions. If I remit $8,000 and I've had $5,000 worth of expenses paying for leave to my eligible employees, then I can deduct that from my $8,000 and only remit $3,000 to the federal government. That is how you get reimbursed for your cost of providing the benefits. If for some reason, and I don't know how often this would happen, let's say you paid out $10,000 worth of leave payments and your bill is only $8,000, you can keep the $8,000 and you can request an expedited credit to your future payment of your taxes. So how quickly that expedition or that expedited request would be handled, I don't know. But there are ways for you to be able to get that money back, flowing back into your organization. So it's important to take advantage of that. It's important to work with your payroll company or your internal payroll professionals to make sure that they're set up to do that as quickly as possible. Because again, starting next week, the eligibility for these leaves are going to start taking effect. Okay, so Jay, that's generally, I think, everything that I can kind of think of. I'm sure I missed something here or there, but if there's any questions, I think the value of this may be in the answering of the question. So I certainly want to make sure we have time for that.
Yeah, no, thank you, and appreciate that. Again, for those of you, if you missed some of it, the document is at the top of the chat section. There's a link that goes to the website where the Cliff Notes are hosted. Nathan, we had a couple questions before the session that we wanted to address.
All right.
The first one we talked about was regarding healthcare providers,
right?
And I guess overall what that definition means.
Okay. And this is the beauty of early questions, because honestly, I had no idea. I had to look it up. I had to do some research into that.
No, don't say that.
And I found something that was on point, and it's informative, but it's a little scary, to be honest with you as well. The act is borrowing from the FMLA the definition of medical employees or healthcare providers. And honestly, it's a very restrictive definition. The information and I'm going to read a lot of it to you because I want to make sure I got it correct, is that it borrows from the Family Medical Leave Act and its regulations. And for the purpose of the act, the following categories of healthcare providers can be excluded from the ability to take leave. And that includes doctors of medicine, podiatrists, dentists, clinical psychologists, optometrists, and chiropractors when practicing within the scope of their practice, nurse practitioners, nurse midwives, clinical social workers, and physician's assistants when practicing within the scope of their practice. Now, it even goes on to say in here, notably, and this is what came as a very big surprise to me, nurses, nurses assistants, pharmacists, and pharmacist techs are among the direct patient care providers not included in the definition of healthcare provider and cannot be excluded from the coverage of the Expansion Act or the Sick Leave Act. So I was shocked by that, to be honest with you. I thought a nurse would certainly fall into that, and certainly would be a pharmacist, because I would assume that there's going to be a lot of activity in pharmacies over the next couple of months. Yeah. The last part of it here, Jay, says it is important to note that the definition borrowed by the Family First Coronavirus Response Act applies only when the provider is licensed to practice in the state where they're practicing and when practicing within the scope of their practice. As a result, there is some uncertainty about whether an employer can exclude a licensed provider who holds a position that does not involve the practice of the provider's discipline, such as, for example, a nurse practitioner who holds a managerial position and does not provide direct patient care. So,
and we'll share that link as well for those of you on the line.
Yeah, again, it's a very narrow definition if you want to exclude someone from one of the leave benefits. It does go on to say that the Secretary of Labor has the discretion to expand that. And I would think, based on my limited understanding of the healthcare industry, that there's going to be enough outcry that I think that's probably going to be something they consider, is expanding that.
And the other one we had regarding the 401k, would emergency FMLA sick leave payments or temporary sick leave payments be handled differently than normal sick pay for the purposes of the definition of compensation for a 401k or profit sharing plan?
No, it's considered compensation, and it should be handled exactly the same. It's actually, in fact, even taxed. So it's kind of strange how the government gives with one hand and takes with the other, but it is a tax benefit, so it should be treated just like any other form of income.
All right. And we've got one on the chat line. How can you articulate how to notate the separate payroll items from normal PTO?
I'm assuming within your payroll system.
Right, and there's an example.
Tracking. I mean, I'm not a payroll expert. I don't do payroll per se, but I would assume that your payroll provider or your internal payroll has an ability to track this time or track this payment. And if they do, I would certainly track it as closely as you possibly can, because at some point you may be challenged to show that you've paid the required amount of time. So if it's possible to track it separately within your systems or with your provider, I would certainly encourage you to do that.
Yeah. And the follow-up here, hopefully that was clear. If you pay out $1 plus pay payroll taxes on that, is the entire amount covered or just the $1?
Covered. I'm not sure I understand the question.
All right, we can.
Subject to the tax?
Correct.
Yeah, everything is subject. Every dollar.
Okay.
Okay.
I don't see any other questions in the chat section. If anyone has questions, you feel free to come. You have to unmute. I think everyone was on mute, but feel free to jump in or shoot me a note as well while we're sitting here.
Yeah. Jay, if I might, while we're waiting for some questions.
Yeah.
One of the other things I posted for Fahrenheit was, basically some workplace concerns and workplace considerations. And one thing I delved on quite a bit, because I do think it's very, very important, is it goes back to your earlier question about how do you control employees asking for time? Do you need proof? Do you need verification? I think this is a time when employers are going to fall back on their culture very, very strongly. I mean, culture is kind of like a buzzword, but I always say that employers have personalities. Every organization is run in a certain way. They have a certain way of doing things. They have a certain relationship with their employees, either good or bad, but it is their culture. And I think during this time when there is a lot of requirements, there's not a lot of net to catch you if you make a mistake. And it's going to rely on your relationship with your employees, the engagement level that they have with your organization. But again, what is the relationship? What is the, how do you treat one another? What drives your decisions and what are your values? And I think those are going to be the very important things that you should lean on when making some of these decisions that are not spelled out in the act. And you have to kind of decide, what am I going to do? How am I going to treat my employees? It's important to fall back on that. Okay, Jal,
we're at 12:37. When you're caring for a friend, is that covered under the 2/3? There were some different payouts that you were referencing earlier.
Yeah, the sick leave is more for individual and family members. The FMLA, the 2/3, that is for the 10 weeks or the 2 weeks initial, it can be for anyone. It does not have to be family. It can be a neighbor that you're particularly close to. It could be a friend. It could be someone that you know that really just does not have anyone else to lean on. The act does allow you to extend to those individuals and take time off to care for them.
Okay. And does the quarantine benefit include overtime pay or just straight time?
It's just straight time. I know in the law, this is kind of off subject a little bit here, but in the law, it does apply to it discusses how to calculate regular pay for people who might have variable hours. If a person doesn't work, of regular hours, and again, an added point here is part-time employees are just as eligible for this benefit as is full-time employees. So it's not a full-time employee, part-time employee thing. All employees are covered. So when you're calculating that normal wage and normal income, they suggest if the individual has a variable income scheme, the hours fluctuate perhaps from week to week, that you should go back 6 months and look at their average hours and their average income over that period of time and reach what you're going to pay based upon that average. So it's a 6-month look back cycle.
Wow. Okay. Thank you. All right. Well, I will, again, just to respect everyone's time, we will post this. It's been recorded. I'll follow up individually with folks who may have had some questions. Hopefully we tackled all of those and can address them further. What am I missing, Nathan? The link to the actual fact sheet, or the Cliff Notes as I'm calling it, is posted here as well. We can distribute that. Nathan is been very gracious and said, anyone has any follow-up questions, let us know. Happy to tackle them. Everyone has unique situations, and this, we want to make sure for you and your specific details and organization that you have enough information. Yeah. Because translating this legislation stuff is tough. Well done, Nathan. Thanks. Scott, just saw you pop back in. Thank you very much again for the quick turnaround and organization on this. Information overload in some regards, but hopefully we are making it efficient and effective for everyone. And if you need anything from me, Fahrenheit, feel free to reach out. Thanks, everyone. Stay safe, and we'll be in touch soon.
Okay.